So let us begin. I'll start then with introducing your speakers for today. Neil Cameron QC will be known to many of you. He has extensive inquiry and court experience, including appearing in the Supreme Court on a number of leading planning cases, such as Wright against the Forest of Dean and Resilient Sevendale. That was a case about whether payments to a community benefit fund are a material consideration in the case of a wind turbine. That was a case I was also involved in, although unfortunately for me on the losing side. He was also involved in the, appeared in the recent seminal case on the duty of planning authorities to give reasons. That was of course Dover District Council and CPRE. And a few years before in the case of Morge against Hampshire County Council, which is a leading case on the consideration of the Habitats Directive. His recent inquiry experience includes the very recent decision in the Tulip. Neil also sits as a Deputy High Court Judge in the Administrative Court, including in the Planning Court. Katharine Elliot is a recent recruit to Landmark's Planning and Environmental Group. She has a particular interest in historic environment, including experience of a wider range of planning matters from minerals and water pollution to HMOs and High Court challenges. She was nominated as Young Pro Bono Barrister of the Year in 2019 for her work representing a local campaign group in successfully resisting an appeal against refusal of planning permission for a major sand and gravel quarry in Hertfordshire. Matthew Henderson specialises in planning, environmental and compulsory purchase law. He's a member of the Attorney General's C panel and was ranked in Planning Magazine's top 20 planning juniors under the age of 35. He represents developers, local authorities and a range of other parties in all areas of planning law, including infrastructure planning under the Planning Act 2008. His work also includes environmental law, and he recently represented Natural England and local planning authorities in cases concerning nutrient neutrality and nitrate pollution. And he's currently representing the Coal Authority in a judicial review claim concerning the climate change impacts of authorising further coal mining sites in Wales. So without further ado, let's begin, and I'll hand you over to Neil. Neil.
Thank you, Jenny. Good morning, everybody. Now my talk is on changes to section 38(6), and none of you need any reminder about what section 38(6) of the 2004 Act says, but if you did need any reminder, there it is. But it lies at the heart of decision-making in today's planning system. And we all quote it the whole time. And those of us who are promoting development invariably say that our scheme complies to the development plan, and those on the other side invariably say that it doesn't, because this is the central element of the legislation in decision making. So how is that going to change? That's what I'm going to talk about. And this is how it's going to change. This is quite a dramatic change to the system. So it's worth just spending a little bit of time on the words here. So, and the parts that have underlined, I've underlined because I think they are significant differences. So we start with, if regard is to be had to the development plan and any national development management policies, so that's new. We then get to 5B, the determination must be made in accordance with the development plan and any national development management policies, unless material considerations, this is a new word, strongly indicate otherwise. And then at 5C, what happens if there's a conflict between the development plan and national development management policies? Well, the national development management policies prevail. So significant change, and I suggest that the following questions need to be asked. I mean, question 1 is a fairly fundamental question. When does section 38.5a, which is the new section 38.6, when does the requirement apply? What is the development plan? Well, we're all familiar with that, but there is a slight tweak to that, and that's why I posed that question. And then, what are national development management policies? Because that's a new concept. And what difference will the new system make to decision making? And it's really question 4 that I suspect is going to interest us most. But we need to answer questions 1 to 3, and no doubt hundreds of other questions, which you're all invited to ask. Whether you'll get answers from us is another thing, but please ask them. So let's turn to, when does the requirement apply? Well, I think it's always important to remember that even under the current system, you've got to ask yourselves, when is regard to be had to the development plan? And the answer is when you are dealing with, that is when a decision-making planning authority is dealing with a planning application, because that's the effect of section 70, subsection 2. And you read so many planning proofs of evidence which just refer to section 38.6. But you need section 70, subsection 2 in order to get that, to engage the requirement in section 38.6. And section 70, subsection 2 is going to be changed if the proposals in the draft bill are enacted as law. And, well, in the bill, not the draft bill, by adding any national development management policies so far as material to the application. So added to the list where we've got the development plan, local finance considerations, the Welsh language, and any other material considerations, is going to be national development management policies. So you have to have regard to them when you're determining or dealing with the planning application. So that's a fairly simple one. When does the requirement apply? What is the development plan? Well, it's pretty much the same as it is now, but there are additions, because clause 82 will insert a new subsection in section 38 of the 2004 Act, and the additions are supplementary plans and the policies map. And you may say, well, the policies map should always have been there, and it should have been, but it will now formally be there. Now, supplementary plans are a new category. They are the new supplementary planning documents, but it's going to be different because they are going to be subject to examination. But the general rule is going to be that that examination will be carried out by written representations. You just need to watch out for this, because these supplementary plans can't be cast aside like SPDs often are as other material considerations, because they are going to form part of the development plan. Now, what are national development management policies? And the answer can be found in the new section 38ZA. And that is a policy, however expressed, of the Secretary of State in relation to development of use of land in England or any part of England, which the Secretary of State, by direction, designates as a national development management policy. So a national development management policy is what the Secretary of State says it is. But we have some further information on this, because at the same time as the bill was published, the department published a policy paper with further information. And if you haven't read that, it's worth reading that because it explains what the government is trying to achieve. These national development management policies, it said, will be derived from the policies set out currently in the NPPF, where these are intended to guide decision making. So they will be, the starting point will be the decision making policies from the NPPF. They will become national development management policies. They will have equivalent plus status to the development plan in the current system. And if there is a conflict between those policies and the development plan, the conflict will be resolved in favour of the national development management policies. So at the moment, we have this rather curious system where, although planning inspectors and others pay a lot of attention to the NPPF, it is in fact, of course, just another material consideration. Well, its status is going to be elevated. It's going to be central to decision making, and if there's any conflict, those policies prevail. So we're going to have to look really carefully at what are the national development management policies. And I suspect that the government, when it designates these, will have a look at the NPPF, some tweaks will be made, and some clear guidance will be given. So what difference will the changes make? So, as I've already said, these national development management policies will be derived from policies on decision-making in the NPPF. They won't be just some other material consideration. So what happens? You've got your planning application. It comes in, the local authority have to consider it, but they're going to have to consider it against these national development management policies. And at the beginning, they may have an adopted development plan, which hasn't been adopted under the new system, and they're going to have to give preference to the national development management policies. They may be reluctant to do that because they've got a development plan. It's a development plan for their own area. They've promoted it, considered it carefully, and they will want to make decisions in accordance with that development plan. But what happens when it conflicts with the national development management policies? Well, you're meant to give preference to the national development management policies. And I suspect that is going to give rise to a lot of argument, because people promoting development will say, well, actually, there's a conflict between your local development plan and the national development management policies, and therefore you should give us permission on the basis of those national policies. And now we have the force of statute behind that argument. So that's one consequence, and I expect quite a lot of argument on that point. Now, another consequence of the change is the introduction of the word strongly into the statutory language. So at the moment, it can often be argued, and for example, it will be argued when a local authority can't demonstrate a 5-year housing land supply, that notwithstanding conflict with the development plan, for example, on settlement boundaries, planning permission should nonetheless be granted because other material considerations indicate otherwise. And although there is described as a presumption in favour of the development plan, it's capable of being rebutted and often is. For example, in the case that I've just quoted, when there is an insufficient supply of housing land. Well, here the system's going to change quite considerably, because it won't just be if material considerations indicate otherwise, they will have to strongly indicate. So if you have a proposal which is in conflict with the development plan and the NDMP, you're going to face an uphill struggle to get a planning permission, because some effect has to be given to that word strongly. And I suspect that one of the purposes of this is to ensure consistency in decision making and to ensure that decision making takes place essentially in accordance with the NDMP. So, and I think, as I've already said, that the initial operation of the system is going to cause a certain amount of trouble when there is conflict between the local plan and the NDMP. But of course, under the new system, it's envisaged that local plans will be much shorter, will incorporate the NDMP, and will deal with genuinely local issues. So that will be resolved. But in the short term, there will be a lot of argument, a lot of debate, and no doubt that will take place in the planning appeal forum. So just before we go on to design and the historic environment, to wrap up on this, this is a very significant change. Keep a clear eye on NDMP. Be very wary of the fact that NDMP will prevail, and don't, if you're promoting development, seek to rely on other material considerations to outweigh NDMP in the local plan, because you're going to find it difficult to do so. There will be cases, but it will be difficult. So substantial change if the bill survives in its current form. And I'm now going to hand over to Katharine Elliot, who's going to tell you all about design and the historic environment.
Thank you very much, Neil. Good morning, everyone. As Neil mentioned, I am going to be talking about design in the historic environment. I'm actually going to switch it up slightly because I'll be talking about historic environment first and then design. A quick sort of overview of the topics to be covered, because there's quite a few changes being made all over the bill in various different clauses. So I'm first going to be talking about the amendment that will apply the special regard or special attention test to all designated heritage assets rather than just conservation areas and listed buildings. An amendment that will place historic environment records on a statutory basis. Then going to enforcement, the introduction of temporary stop notices for works done to listed buildings without consent, a couple of other heritage related changes, and then moving on to design and the requirement for all LPAs to have design codes in place for their area. So starting then with special regard. So this is clause 92 of the bill. We'll be amending the Town and Country Planning Act 1990 to insert a new section 58B requirement for the LPA or SOS, depending on who's making the decision, to have special regard to the desirability of preserving or enhancing a designated heritage asset or its setting if they are going to be affected by the proposed development. So that's a consideration when they're looking at granting planning permission or permission in principle. And designated assets, heritage assets under this section will be scheduled monuments, registered parks and gardens, protected rec sites and world heritage sites. And definition is given as to what preserving and enhancing means, and that is preserving and enhancing any feature, quality, characteristic of the asset or its setting which contributes to the asset's significance. And the asset's significance is effectively what made it eligible for the designation it has. So in section 58B in the amendment, you'll see a table which has on one side the designated asset, and then on the other side a direction to where the definition of significance can be found in the designating legislation. clause 92.2 of the bill also amends paragraph 8 of Schedule 4B of the same Act to add the same requirement, so the special regard test for decision makers examining neighbourhood plan development orders. So what's the impact of this? As I mentioned in the introduction, the impact is that it secures for other designated assets, heritage assets, the same level of consideration as currently enjoyed by conservation areas under Section 72 of the Listed Buildings and Conservation Areas Act 1990. Now, listed buildings under the same Act in Section 66 do enjoy halfway house of consideration as things stand, because there's special regard to preservation, but in order that everything's levelled up to the same standard, there's also an amendment in the bill to insert and enhance to Section 66. So across the board for conservation areas, listed buildings and those designated heritage assets I mentioned earlier, the standard is preserve and enhance, and having special regard to that. Helpfully, because they've been around for a while, there's a wealth of case law on Section 66 and Section 72, and obviously Section 72 case law will be of the most help, I would suggest, because it does cover the preservation and enhancement test. And I've given the Safe Rottingdean case there and the full citation, which actually considered both. So that's, I think, a good place to start for those wanting to look at how the courts have approached those sections in the past. The impact on this is effectively drawing the legislation in line with the high-level policy position in the NPPF as it stands, which in various places uses language such as protect, conserve, sustain and enhance, for example at paragraphs 190 and 197, etc. And also the national guidance, which talks about preservation and enhancement. So here we see the legislative language drawn in line with that. And also, as you'll be aware, the wider category of designated heritage assets, so beyond conservation areas and listed buildings, was already needed to be considered on a policy basis within the NPPF. So at paragraphs 200 and 201, with different standards of asset requiring different justification in regard to substantial harm, so exceptionalism and wholly exceptional and wholly exceptional. So effectively, this puts the need for consideration by the decision maker on a statutory footing. And the intention, I think, is that there'll be uniformity in decisions about impacts on designated heritage assets across the board, and hopefully be helpful in terms of scoping assessments, making sure they're consistent, as well as on a decision-making footing. So moving on then to historic environment records. Now there's already a policy requirement in the NPPF at paragraph 192. Maybe requirement is putting it too high, a strong encouragement to LPAs to include historic environment records. But as many of you will be aware, there have been cases where HERS have been shut down and got rid of. So if this amendment comes in, it's set out in clause 185, they'll be obligated to maintain the historic environment record for the area. A definition of what that will include is in 1852, and I've done a high-level summary of it there. So the system will store and make available information about designated heritage assets from the area, any local site of relevant interest, and details about investigations or studies into heritage and the historic environment in the local area, so archaeological, historical, artistic, etc. And that definition reflects the need to identify designated heritage assets, as I said, which is obviously relevant for the amendments we've just looked at, but also a more nuanced local picture, so things that the local authority thinks are of relevant interest and sort of ongoing work into the historic environment. And that ties in the requirement to detail investigations and studies into the requirement at 1855 that the local authority must take reasonable steps to obtain information, and also to keep the record updated, and obviously including ongoing investigations or studies is the best way to keep the information updated and indicate the direction of travel for historic environment assessment in the local area. The Secretary of State is going to put in place regulations about the fees that local authorities can charge those wishing to use the historic environment records, but it's not clear currently the level that they'll be set at. As I mentioned, local planning authorities have historically shut down records because they're not free, they're not cheap, and especially with this requirement for updating, it is likely to be an expensive exercise, and there are concerns in the sector widely about the pressure that this additional statutory requirement will put on local planning authorities who are already rather under the cosh in the current climate. So moving on then to enforcement, in the bill we also see the introduction of temporary stop notices in England, because they are in force in Wales at the moment, and that will be by an amendment to the Planning, Listed Buildings and Conservation Areas Act, and it will be to insert a new section 44AA. Section 44A is the current injunction system, and the authority to issue a TSN would arise where it appears that works have been or are being executed in relation to a listed building in contravention of the prohibitions in section 9.1. So that's a breach of the section 7 prohibition on unauthorised demolition, alteration and extension of listed buildings, or it's in contravention of section 9.2, which is breach of a listed building consent condition under section 8 of the Act. And also, having regard to the effect of the works on the character of the building, they consider it expedient that works or part of the works should be stopped immediately. Unsurprisingly, the amendment also sets out the various procedural requirements as to the content of the notice, the effect of service, its publication and display. So a copy needs to be displayed on the actual building. In terms of the period that the TSN will cover, it will be effective from the date of first display at the property for a maximum of 56 days. Once it's expired, the LPA can only issue a fresh TSN if they've taken alternative enforcement action first. So that would include an injunction under section 44A, which already is in effect. So that will stop LPAs from effectively issuing TSN after TSN after TSN without end while they conduct the investigations. Because effectively, a TSN's purpose is to allow the LPA time to investigate the situation and ascertain whether, in its view, section 9 has in fact been breached. But it will only have 56 days to do that before the TSN comes to an end. The LPA can specify a shorter period for the TSN. It can also withdraw the notice before expiry, for example, if it's satisfied that there's no breach of section 9. And because of the compensation right, which we'll come on to in a moment, LPAs, I think, would be encouraged not to have a TSN in effect longer than is absolutely necessary. There's also going to be the creation of criminal liability for breach of a TSN. That's going to be in section 44AB. And that will be subject to limited defences, for example, reasonable lack of knowledge of the existence of the notice. And there are other defences about the necessity for carrying out the listed building works. For example, it's essential for the continued existence of the listed building. And the penalty would be a fine calculated with regard to the benefit accruing or likely to accrue to the person who has been prosecuted. So continuing with TSNs and the right to compensation, which I mentioned a few moments ago, there'll be a right to claim compensation for those with an interest in the building for any loss or damage, including arising from breach of contract, which is directly attributable to the TSN if the works are not found to be in breach of section 9.1 or 2, or the LPA withdraws the TSN other than after granting listed building consent, because that's another reason when the TSN might be withdrawn is if listed building consent has been sought and granted. So this is the danger area for LPA. So if they issue a TSN and it's not a breach of section 9 and they didn't have to grant listed building consent, then there is a right to compensation. It's subject to one point, which is that the compensation right won't arise if the claimant was required to provide information under a relevant provision. So the relevant provisions are Section 16 of the Local Government Miscellaneous Provisions Act 1976 and Section 330 of the Town and Country Planning Act 1990. So if they're required to provide information under that one of those provisions and they didn't, and the loss or damage they suffered as a result of the TSN being imposed could have been avoided by their providing it, or otherwise cooperating with the LPA, they won't be entitled to claim for compensation. The Secretary of State is also going to have concurrent powers to issue a TSN, and this is another instance where these amendments are going to bring England in line with the position in Wales. Now, as with every other enforcement measure that an LPA might take to protect the built environment, where there's a compensation provision attached, there is a fear that whilst this looks like it's empowering LPAs will be very reluctant to use it unless they're absolutely certain before they impose the TSN that there is going to be a breach of Section 9, just because the possible cost to the LPA, if that's not found to be the case, for who knows what level of loss or damage depending on the building, that's a very significant risk, again, for local authorities who are not in a position where they're flush with cash, far from it. So there are concerns that this power isn't actually going to be exercised, save in very, very clear cases of contravention of Section 9. So moving on to cover quickly a couple of other changes coming out from the bill. Another situation where England's being levelled up to Wales for urgent listed building works currently under Section 54. Local authorities are allowed to carry out works which appear to be urgently needed for listed building preservation only on parts of the building not in use if the building is occupied. And the amendment would allow works to be carried out on buildings in residential use, regardless of the areas that are being used, if those works wouldn't unreasonably interfere with use, subject to a 7 days written notice requirement. And then compensation for building preservation notices is being attached to the TSNs. It's going to come off the building preservation notices via an amendment to Section 29. So in Wales, they'll have a compensation requirement, but in England, there won't be a right to claim compensation. So the view is that TSNs won't be used unless exceptional circumstances because of the compensation, but BPNs, this might encourage LPAs to use them more than previously. And it'll be interesting to see if that is in fact the case. So moving on to design. Securing good design. Again, this is a situation where the legislative position is being levelled up to reflect the language in the NPPF on a policy basis. So this is in clause 87 and schedule 7 of the bill, amending the Planning and Compulsory Purchase Act 2004. Now, we will be aware that there's already a requirement for someone or body exercising functions in relation to local development plan. They're required to have particular regard to the desirability of achieving good design. That's set out in Section 39(2)(a). And the NPF in various places refers to good design. So in PCPA, to facilitate that securing of good design, LPAs are going to be required to put in place design codes for every part of their area as part of their development plan. And that will be the new Section 15F. In terms of what design codes are, there's a definition in Section 15F, and it's requirements with respect to design that relate to development or development of a particular description, which the authority considers should be met for planning permission to be granted. Now, there's already a strong encouragement in the NPPF for there to be design codes in place. That's paragraph 128. And there is a definition of design code in the NPPF, which I won't read out, but it is in there. And one of the requirements is that it should be consistent with the principles in the National Design Code and National Model Design Code. And although there is a definition in the proposed section 15F, I don't see any reason why the sort of expanded definition in the NPPF and the reference to the NDC and NMDC should not apply if this comes into effect. It's emphasised that the design codes don't need to be exhaustive for all development categories or design aspects, but the LPA will be expected to demonstrate compliance with this new requirement in its local plan timetable. And very quickly, because I'm conscious of time, the SOS will be given various intervention powers to require the LPA to comply if they haven't complied or are likely not to comply with the new requirement, including directions and temporary directions, and they'll be entitled to seek reimbursement from LPAs for any costs incurred as a result of that required intervention. So that, in summary, is the changes that are going to be made if this bill comes into effect with regard to historic environment and design. And without further ado, I will now pass over to Matthew Henderson to speak about environmental assessment.
Great, thanks very much, Katharine. So my discussion today is on environmental assessment within the bill. So if we wind back, how did we get here? Well, we go back to August 2020 and the excitement of the white paper. It is from there that we see at least some of the themes that have now made their way into the bill start to emerge, probably three key themes. Firstly, the idea of reform, but without any lesser protection. We see that, for example, references to 25-year environment plan, the idea of a proactive role in promoting environmental recovery and long-term sustainability. Second theme of Brexit, the idea of greater control by the Secretary of State over the nature and scope of environmental assessment. That was flagged too in the white paper. The fourth bullet point or fifth bullet point there, outside of the European Union, it's also important that we take the opportunity to strengthen protections. And then the third theme, one of efficiencies. So the final couple of bullet points there, quicker, speedier decision making, clearer timescales, a process which is simpler, consolidated. So that was the vision. Where are we now? Well, we've got the bill, but we've also got an explanatory document. It's available online, Levelling-Up and Regeneration, further information, which is a helpful comparator actually to the white paper, gives you some indication of the direction of travel today. And similar themes, so fostering better environmental outcomes, so that first theme that I picked up, but also an environmental outcome reporting structure, and I'll come back to explain what that is, to replace EIA, so environmental impact assessment, SEA, strategic environmental assessment, and SA, sustainability appraisals, and something that, again, clearer and simpler, so picking up that third theme that I highlighted, and then in somewhat more colourful language, an assessment against tangible environmental outcomes set by government rather than in Brussels. How far that was ever actually a problem in the world of EIA and SEA is perhaps a matter for debate. Nevertheless, the same themes in broad terms being carried through to the bill. So against that background, where are we now? Well, to outline the new process as it appears, and I stress as it appears because essentially there will be extensive regulations made by the Secretary of State which will set out the detail of the new environmental assessment process. What we have now are the enabling powers, giving us a broad indication of what the scope of those regulations will be and what sort of matters they are likely to contain. But beyond that, we don't have much in the way of detail. So key parts of that process, well, firstly, clause 116 of the bill and the concept of specified environmental outcomes, so the ability of the Secretary of State to define particular outcomes. The partner provision to that is clause 117. This is the requirement for an environmental outcome report to be prepared in relation to any relevant consent or plan. I'll come back to what that means and the scope of that. But importantly, and as you would expect, there's a prohibition on proceeding with your consent, your development or your plan without having first put in place your EOR. And then a series of additional provisions, assessment monitoring in clause 119, enforcement in clause 123, reporting clause 124, and then a new and perhaps important duty in clause 126 to have regard to new, as yet to be published, guidance by the Secretary of State. All of those latter 4 provisions are at a very high level, but we do get, at least from clause 116 and 117, the sense of the shape of what is to come. So let's dig into some of the concepts in a little bit more detail. The first key concept is the idea of a specified environmental outcome. As I indicated a moment ago, what will happen, the Secretary of State will be able to specify by way of regulations a series of outcomes on the subject of environmental protection. What does that mean? Well, it's broad in scope. It's broad in 2 ways. Firstly, as to the topic, so the natural environment, cultural heritage, landscapes, people, and the effects of human activity on all of those matters, so thematically broad, but also broad in terms of the nature of the outcomes. So not simply what one might think of in terms of conservation outcomes, protection, maintenance, restoration, enhancement, but also outcomes to do with monitoring, assessment, advisory outcomes and reporting outcomes. So within those thematic bounds, the cultural heritage, buildings, structures, things that have been carved out of the natural environment, but linking back to concepts that we know, so those of historic, architectural, archaeological or artistic interest. And of course, your welcome copy of the NPPF and the definition of significance in the back of that will be ringing in your ears when you hear those words. And then a requirement for the Secretary of State to have regard to the current environmental improvement plan under the Environment Act 2021. So that's specified environmental outcomes. So that's set in the structure, and that really is picking up on that second theme that I talked about at the start, the ability of the Secretary of State to take control and to set their own structure for environmental assessment. Now, the second key concept is in clause 117, environmental outcomes report. I think the great question is this just another word for an environmental statement? Possibly. Let's wait and see. It's got to be a report that is in writing. And what's the key test? Well, you need to record the extent to which the proposed consent or the proposed plan would or is likely to impact on the delivery of specified environmental outcomes. Now, it seems to me that this is an area where there is undoubtedly going to be further litigation. Where do we set that threshold? What does would or is likely to mean in this context? All battles that we fought before in the EIA and in the habitats arenas, but nevertheless ones which will be the subject of further litigation, I'm sure, here. In addition to that, you need to record steps to deal with a range of different environmental objectives, so delivery, non-delivery, and then taking into that really the mitigation hierarchy, so avoiding those effects, mitigating those effects, remediation of those effects, compensation for those effects. And that is enshrined in clause 117, but again, subject to the detail in the regulations as they appear. And importantly, steps for these purposes includes reasonable alternatives. So all of that litigation that we've seen before about reasonable alternatives and failure to have regard to reasonable alternatives and what are reasonable alternatives, all of those matters are going to be live again, I think, when we come to these sorts of reports. What will be interesting, though, I think, is to see what sort of approach do the courts adopt. At the minute, we have the Bluett, Friends of the Earth, Heathrow approach, one of reviewing on Wednesbury grounds, a question of irrationality as to whether the report is or capable of being described as an environmental statement. Is that approach going to persist? Well, there's nothing to indicate that that's going to change here, so I suspect that the Planning Court will adopt a very similar approach when it comes to challenges based on the environmental outcomes report. Third key concept is that of what's a relevant consents and relevant plans, and this is in clause 118. So starting with the basis 2 types of consent, a category 1 consent and a category 2 consent. And this will be something that we are relatively familiar with the determination of what is or is not EIA development. So category 1 consents, those matters which will always be a relevant consent, i.e. will always engage the regulations. Category 2 consents, those which may be a relevant consent subject to the satisfaction of particular criteria, all matters that we're used to at present in terms of screening and scoping. Relevant plans, defined very broadly, relating matters which relate to a project or to environmental protection, which are specified in the regulations themselves. But that really reflects the breadth of the SCA regulations at the minute. See, for example, the right to community action litigation most recently around the GPDO and the discussion there by the Divisional Court as to the SCA regulations. So that's broad, but not, I don't think, a change from what we're used to. Consent, again, broadly defined. So any of those matters that I've listed there, which are in relation to a project. Importantly, it's a consent or approval or decision that is required or otherwise provided for by or under any enactment. And that seems to be likely to be a point of certainly initial dispute. And then a project widely defined, not simply construction, includes demolition and indeed goes so far as to be any other activity capable of affecting the natural environment. And of course, in recent times, we're used to thinking about, for example, agriculture and Dutch nitrogen in the habitats scenario. The European courts there saying that agriculture can, for that purpose, be a project. What about fishing? What about other forms of activities that one might not think of immediately as being projects or development projects? Well, there is the potential, I think, subject to the regulations, for those matters to be caught. And I would be surprised if the regulations don't give more specific guidance and seek to delimit this further. So that's the third key concept, and the fourth key concept is one of non-regression and safeguarding. So picking up that first theme that I outlined in the white paper. So the Secretary of State's power to make the EOR regulations is one which can be exercised only if he's satisfied that making the regulations will not result in environmental law providing an overall level of environmental protection that is less than that provided by environmental law at the time that the Act is passed. So the idea is nothing less than what we have now or will have when the Act is passed. And that's clearly important for the strategic objective that I outlined earlier. But as this is going to be approached through secondary legislation, one can't rule out the possibility of a challenge to those regulations when they're made. And it seems to me that this is one of those areas where a challenge is likely to focus. Has the Secretary of State ensured that the level of protection is no less than what we have now? Further additional provisions in respect of ensuring there's no inconsistency with international obligations. And then finally, tucked away in clause 120, the concept of keeping the public informed, so dealing with consultation, that is broadly defined. The obligations to is to have adequate public engagement. One asks, well, what is adequate public engagement? Well, it's that engagement which the Secretary of State considers appropriate. So we're not really eliminated any further. But clearly, those parts of the EIA regulations, especially, for example, reasons, see Neil's case, CPRE in Dover, are very valuable. And in the wider context of the Aarhus Convention, those parts really matter on a day-to-day basis. But at the minute, we have very little information as to how they're going to be preserved or in what form. And then finally, clause 120 deals with a series of exemptions in terms of national defence, preventing or responding to civil emergencies, and then a bespoke provision for the Secretary of State to be able to make directions which will exempt certain projects from the requirement to go through this process. So overall, if I go back to those three themes from the white paper, where are we? Well, is there greater independence for the Secretary of State? Yes, undoubtedly. The ability to set environmental objectives through the regulations, I think, clearly ticks that box. Is there greater simplification? Possibly. There is, I think, simplification in terms of the legislation. We won't have the EIA regs, SEA regs sitting alongside each other. We are going to have a simplified process. But I think there is quite a lot to be seen as to whether in practice we have simpler documents. Are we still going to have multi-volume environmental statements, but now called environmental objective reports? Possibly. I think that the jury's still out in that regard. And then thirdly, that key theme, is there going to be any lesser protection? Well, clause 120 on its face suggests not, but I think we need to see these regulations first to work out whether or not that will in fact be the case. So Jenny, I think it's back over to you for the Q&A session now.
Yes, thanks very much, Matthew, and thanks to all the speakers. If everyone could put their camera back on, and we'll go through, we had quite a few questions actually. So going right back to Neil's talk, I wanted to start with this tension between localism and the prevalence, the statutory kind of priority now given to the national development management policies. Neil, is this the end of localism? And there's some sort of policy statement alongside the bill which says that local plans will be given more weight. And someone's asked a question about that. Is that really the case, or is this a power grab by central government? What do you think about that?
Well, I think this could be described as the partial end of localism, which is a bit of a fudge of an answer. But can I explain why? I think initially, and this is what I said in my talk, there will be a tension between local plans and the national development management policies, and local plans will be given more weight because other material considerations have to strongly indicate otherwise, but they won't be given that much weight and the questioner gets to this point, in that the national development management policies will prevail. So to begin with, there will be a lot of argument about, is a local plan consistent with the national development management policies? People will say, no, it isn't, and the local plan won't prevail, and localism will not prevail. But once the system is bedded in, the idea is that a local plan won't have to repeat national development management policies, so the plan will be the standard policies, which are the national ones, plus specific local ones. And once that system is in, then local plans will be given weight, but they just won't repeat development management policies, which are in the national policies. So the answer is end of localism to begin with, partial end of it long term, but there is still a role for development plans. So local authorities don't give up and carry on preparing development plans.
I mean, you say, I think it could be very long term though, given how long it can take for new local plans to come forward. For some areas, it may take more than a decade for that simplification to come through.
And I think until that happens, the national development policies are going to reign supreme.
Yeah.
So I suppose it might be said, well, there is an incentive for local authorities to promote local plans, because then they will have a say. If they don't, they won't. But they might say, well, we have to do it every 5 years. We're going to be overridden by national development management policies, so why bother?
Yeah. And one thing that occurred to me is, will it be for the court or for the planning authority to decide whether there's a conflict, or the court or the decision maker to decide whether there's a conflict between national policy and local plan policy? Who defines whether that's a conflict, and then it prevails, or is it a matter of planning judgment whether there's a conflict? I mean, I think that would be an interesting point in the courts.
It will, but I think the answer will be it's a matter of planning judgment, because you have to consider the plan as a whole, and you have to consider the national development management policies as a whole. And if you look at the cases when we had structure plans and local plans, that was held to be a matter of judgment. So I think it would be a matter of judgment, unless it went so horrendously wrong that it became irrational. But that's, who knows? I know that will be argued, but That's my view, matter of judgment.
Yeah.
For the decision maker.
Yeah. And I think also this is going to give rise to a raft of litigation again, isn't it? We've had all the litigation on paragraph 14, then paragraph 11 of the NPPF, and now we're going to have a lot of litigation on how these provisions work, I expect. So simplification, but probably more argument. Okay, the next question. It talks about the National Development Plan policies are going to be derived from policies on decision making in the NPPF. And obviously the rest of the NPPF is focused on principles taking into account plan making. Are there going to be any gaps, do we think? Because you've got national development planning policies to date are described as relating to greenbelt landscape heritage. Does that mean that there are policy areas that are not covered and that will only be covered by development plans? I think this is your point before, isn't it? Where you have, where hopefully in the relatively near future, you'll have a clear allocation between what's to be covered by local plans and what's to be covered by the national planning policy.
I think so. I don't think this will cause a great problem, because if greenbelt policy, for example, is in the national development management policies, it doesn't need to be repeated in the local plan. And what the local plan can concentrate on is allocating sites for development, identifying special areas that need protection if it's appropriate to do it on landscape or density. And so the idea behind it is a good one. There's no point development plans replicating national policies. But where there aren't national policies, then it's up to the local authority to have a policy.
Yeah.
So I don't think that's going to cause a problem at all.
No. Okay. Let's just move quickly on then to the other areas, the historic environment area. Katharine, in terms of maintaining the historic environmental records, will that be the responsibility of counties or districts?
So clause 185, which is the obligation to maintain, refers to relevant authority. And then at clause 1858, it defines that as county councils and then district councils if there isn't a county council for the area, each London Borough Council, and then various other relevant bodies, including national park authorities. So it will depend. If you're a DC for an area where there's no CC, it's going to be your obligation. If you're the CC, it's going to be your obligation, basically.
Yeah. Okay.
That's a short answer.
Another quick question for you. Is there any change, as far as you know, in relation to locally listed assets? So rather than national designated assets, is there any change in relation to those?
No, the only assets, heritage assets that are going to be impacted by the change to the Town and Country Planning Act are the ones I mentioned earlier. But there is obviously in the NPPF still that requirement to have regard to the historic environment as a whole. So while they're not sort of given the same level of consideration, they're not disregarded, but they aren't, as you say, impacted by this sort of levelling up of importance.
Yes, they're not giving any statutory recognition. It's back to the NPPF on those. Yeah, okay. I think we're just about out of time, actually. We have got quite a few questions here. Let me just see if there's one more we can deal with. Let's have a quick look. Just back to Neil briefly on supplementary plans. Are they to be made by developers rather than local authorities, an amount to the privatisation of planning, or are they what we know as currently as supplementary planning documents? I think it's the latter, isn't it?
It is.
Yeah, yeah.
But they're going to have more status than SPDs, and they'll have to go through a process, examination. But the general rule is going to be by written reps.
Yeah. And in terms of the settling what the National Development Plan policies are going to be, is there proposed to be around a public consultation in relation to that?
The information paper says that there will be consultation. What form it will take, I don't know. But there will be consultation. But if it turns into a full-blown consultation, it'll get too bogged down. So I suspect it'll be fairly light touch.
Streamlined, yeah. Okay, well, we've come to the end of our time. So thanks very much, everyone. And thank you all for all the questions. And I hope you found it informative. As I said at the outset, there will be an email sent to all of you with a link to the recording. So you'll be able to go back over anything. And I think we're also sending the slides, so you'll have a record of those. But thanks very much for attending, and hope to see you soon. I think there's another one in this series coming up in the next week or so. So we hope you can see you all there as well. Thank you very much.